Welcome to Part-2 on the law of damages in India. I am Sushila Varma, the Chief Consultant and co-founder at the Indian Lawyer and Allied Services. Should you have any further queries on damages in India, please feel free to contact us at the email ID that is available at the end of the presentation. This episode has to be read in conjunction with Part 1 of Law of Damages. A contract may contain express or implied terms that in the event of fulfillment or non-fulfillment of such terms, the parties are mutually discharged from their obligations. In such cases, a breach of contract can discharge the parties from further performance. A contract may also contain a provision that makes it determinable, that is, it terminates at the option of one of the parties. Such contracts are generally in cases where services are provided. The parties to a contract are free to create special rights and obligations within the contract, such as providing a proper measure of damages in case of breach. The contract may require that the party that claims breach gives a notice as a precondition of claiming any relief under the contract. Notice also becomes mandatory in case the aggrieved party wants to cancel the contract. Parties are also free to add a term in the agreement that in the event of breach, they will not seek compensation from each other except refunds of amount paid. This is a waiver clause. In some cases, parties also exclude or restrict their right to claim damages for breach of contract. Such a term is valid provided the language of the contract is clear, precise, and unambiguous. As contracts are commercial in nature, it is not normal for parties to forego damages in a breach of contract. Hence, such a provision must be clearly set out. Contracts can have clauses that are essential and that go to the essence of the contract. Parties can also have a warranty or indemnity clause which is deemed to be an essential promise for the aggrieved party. Such a clause can come to the rescue of the aggrieved party in the event it is sued by a third party for damages that it is not aware of or is liable for. In a Delhi High Court judgment of Varma Investments versus National Insurance Company, the bench held that as per the indemnity clause stipulated in the contract, the respondent insurance company was liable to indemnify the plaintiff company for the loss incurred in purchase of shares. Damages as a right. Damages as a relief is available as a matter of right when a contract has been breached as against a relief of specific performance which lies in the discretion of the court. An action for breach of contract or for damages can be made only if the contract is concluded and is valid under the eyes of law. A contract must therefore meet all the mandatory conditions for a valid contract as laid down in the Contract Act, which are as follows. Proper offer and its acceptance, lawful object, lawful consideration, compliance of legal formalities of registration, attestation, stamp duty, etc., intention to create legal relationship, free consent, competence of parties to contract, for example, parties are of sound mind and have attained the age of majority, certainty of terms and conditions, possibility of performance, and an agreement not expressly declared void under the laws of India. Contracts can only be upheld by the law if they are legal in nature. Damages can only be awarded by a court if it has come to a conclusion that there has been a breach by the defaulting party, causing a loss to the aggrieved party. Further, where a contract is rescinded, which affects its formation, such as in the case of fraud, the party will be restored to the same position as it was before the contract was entered into. When a contract which is not void or voidable or liable to be set aside in equity is dissolved by one of the parties who has failed to observe an essential condition or committed a breach that goes to the root of the matter, the contract stands terminated and the defaulting party can be made liable for damages. But there must be an upper limit to the liability of the defaulting party, and the said damage should not be too remote so as to make it irrecoverable. In every action for damages, the court has to examine several factors before assessing and ascertaining the quantum and measure of damages, such as remoteness of damages, mitigation of losses, the contractual terms, etc. The quantum of damages deals with the amount of damages, whereas the measure of damages involves consideration of law as well. Some of the factors that are examined by the court for assessing damages are given below. The aggrieved party has to prove the existence of breach of contract, has to prove the loss or injury suffered due to such breach, prove that such losses were contemplated by the parties at the time of entering into the contract, in the event loss or injury has not been proved, then a genuine pre-estimate of the loss as stipulated by the parties in the contract shall be considered as a reasonable compensation. In a Supreme Court judgment, Maula Bucks vs. Union of India, the three-judge bench held that the respondent failed to establish that it had suffered any loss or damage due to non-supply of potatoes and fish by the appellant. Thus, the respondent was not allowed any damages in this case. In another Supreme Court judgment, ONGC vs. Saw Pipes, the two-judge bench allowed liquidated damages to the appellant as stipulated in the contract for the delay caused in supply of pipes by the respondent. The bench felt that the failure to supply pipes was crucial for execution of the contract. In absence of any stipulation of liquidated damages in the contract, the court may assess the amount of damages based on the loss or injury sustained by the aggrieved party after assessing relevant factors. Only direct or consequential losses such as overhead costs, decreased profits, etc., sustained by the aggrieved party by reason of breach of contract will be considered. Any remote or indirect damage or losses would be excluded. In a Supreme Court judgment, Pannalal Janki Das versus Mohan Lal, the three-judge bench held that there was no direct connection between the loss of goods sustained by the respondent and the appellant's failure to insure the goods. In fact, the goods were in the respondent's custody when they caught fire. Thus, the respondent was not allowed any damages in this case. The aggrieved party has taken all reasonable measures to minimize the said losses. Further, the aggrieved party is debarred from claiming any part of the damage or loss which he ought to have reasonably avoided. The extent to which reasonable steps shall be taken by the aggrieved party would be judged based on the facts and circumstances of the given case. In another Supreme Court judgment, M. Lachia Sethi versus Coffee Board Bangalore, the two-judge bench held that the loss incurred by the respondent was due to the breach of contract to pay and take delivery of coffee stocks by the appellant. Thus, the respondent was allowed damages in this case. Damages are capable of restoring the aggrieved party to the same position as it would have been if the particular damage had not occurred or if the contract had been performed. It is pertinent to note that even where the aggrieved party has been able to prove loss, the damages may not necessarily compensate the aggrieved party of his entire loss. It must be borne in mind that ascertaining damages can only be approximate and not exact. For any further queries, please contact us at any of the following addresses. Thank you.